give their attention to the court now sitting.
Thank you. Please be seated. Good morning and welcome to the Supreme Court of Kansas. I understand we have some special guests today seated to my left. Topeka West High School students, is that correct? You'll be pleased to know that one of our colleagues, Justice Rosen, is also a graduate of Topeka West, and he'll be leading you in the fight song in just a few minutes. Ms. Green, as Clerk of the Appellate Courts, we do the honor of calling this morning's docket.
Russell Hazelwood and Jacob S. Grable of Grable and Hazelwood LLC for the defendant, Appellant Ivan Reed.
Jay Fowler, Fulton Secret LLP, on behalf of the appellate Christi.
Number 101,624, State of Kansas versus Sawyer on petition for review on about country briefs both sides.
Your Honors, Reed Nelson representing the appellant. I'm ready for argument.
Support Jennifer Tatum on behalf of the appeal number 105,483, State of Kansas versus Boland, Reno County, briefs both sides.
Randall has been on behalf of Mr. Bolin and Ms.
Pleases the court, Keith Schroeder, Reno County District Attorney, on behalf of the fellow President Reed.
Appeal number 103,918, State of Kansas versus Randolph, Wyandotte County, briefs both sides.
May it please the court, Sarah Ellen Johnson, Capital Appellate Defender Office, on behalf of Mr. Randolph. I'm ready for argument.
May it please the court, Christopher Schneider, Assistant Wyandotte County District Attorney for the appellate.
That concludes the
Thank you, Ms. Green. Now proceed to the first case on this morning's docket. This case number 101690 via Christi Regional Medical Center, Inc., the Ivan M. Reed.
May it please the court, my name is Russ Hazelwood, and I'm here with my partner, Jacob Grable, on behalf of the defendant, Appellant Ivan Reed. I request 5 minutes for rebuttal.
5 minutes is granted.
Thank you. This is an appeal of a summary judgment granted by the district court in favor of the plaintiff and against Mr. Reed, which we are asking this court to reverse. At the outset, I'll point out this case has been ongoing for about 10 years, which is about 25% of mine and Mr. Reed's lives. It felt like it took another 25% to read the briefs and get ready for today. I'm going to try to summarize as best I can in the time I have. Since this litigation was filed, a number of courts, federal district courts, state appellate courts in other jurisdictions, bankruptcy courts have struggled, and frankly this court has struggled with the issue of the growing disparity between the unilateral secretive charges on what is known as a hospital charge master and the market value or the price that people actually pay for those charges. And in my view, courts have, in struggling with that, and really frankly not this court in the Martinez opinion, but other courts have struggled with creating new exceptions or new rules or reasons why we refuse to directly address this issue and continue to refuse to acknowledge that the emperor has no clothes. This case is not like the other cases that have been cited. And the reason is because this case is addressed to specifics. There are a number of other cases where the plaintiffs have addressed the unfairness of charging different people different prices, or the unfairness of discounting, or the unfairness of the secretive charge master in general. This is not that case. Mr. Reed was sued. Via Christi is attempting to use this court system as a vehicle for collection of its charges from him. Like any other defendant faced with charges he disputes, Mr. Reed has sought evidence and to establish that the charges are invalid or inflated or not supported by the evidence that would be a market price. And I'll remind the court, you know this, but these are not charges that Mr. Reed didn't view a menu or do any sort of negotiation. This is a thing where if he had asked how much he was going to be charged, he wouldn't have been able to find out anyway. And in this case, Mr. Reed developed specific evidence directed to specific charges. Evidence of what other people pay, evidence of what other uninsured people pay, evidence of what other insured people pay, evidence of what governmental payers pay, evidence of what the hospital pays for the goods and services, evidence of what the hospital expects to receive from the goods and services, evidence of what competitors charge and receive for similar services, evidence from an economist about how market forces do not apply to the charges that are asserted against Mr. Reed because, one, these charges are not transparent, they're secret. Two, these charges are arbitrary, they're not impacted by any market force, and they're not reasonably related to the cost of supplying the service. And three, they're not what other people pay or what the hospital actually expects to be paid.
Counsel,
Yes.
You're obviously discussing your Consumer Protection Act claims.
Yes.
Are the alleged overcharges, which is what I hear you focusing on since you stood up, is that it? Is that it in terms of the deceptive practice or the unconscionable acts that you're alleging?
No, I've got evidence of thousands of dollars of goods for things that he didn't even get.
Charges for services that were not performed,
Correct.
Or items that were not provided.
I have evidence for thousands of dollars worth of goods where
I've
it's
seen that in
medical
your-
supplies daily and you can't even find out, they can't even tell you what
I've
it is.
seen that in your briefs.
Okay.
Are you making any allegations under the Act based on the method of enforcement of the lien rather than the charges themselves? I believe Judge Lieben, in his Court of Appeals opinion, said that all of your KCPA claims were based on the charges, not on the enforcement.
What Judge Lieben said, as I understand it, is Mr. Reed cannot bring, in order to bring a private KCPA action.
I don't want to talk about the law now. I want to talk about what he says your factual basis for your claims is.
But the only thing that I have that's unrelated to the charges that I can think of as I stand here right now is that they induced Mr. Reed, they entered into a written agreement with Mr. Reed through his representative, his sister, and encouraged her to modify the contract because she negotiated and she made specific changes that they initialed. And now you can read the district court's opinion, you can read the Court of Appeals opinion. Everybody treats that contract as an irrelevant curiosity, and they've tried to avoid it.
I saw that in your brief as well. The encouragement of her to sign the agreement, are you alleging that that's an unconscionable act or deceptive practice?
It could be either.
Okay.
Those are concepts that sometimes overlap.
Speaking of the agreement that was signed by the sister, how are we to treat the portion of paragraph 4 that says that he takes responsibility for whatever insurance doesn't pay? That was not crossed out.
I would have to look at that. I don't have it in front of me. I'm sorry.
Okay. It says, I understand and agree that I am responsible for any remaining balance not covered by insurance.
Okay, I would have to look at that.
Okay.
I will tell you that Reed is not here. He's not saying, he acknowledges at least a moral obligation to pay. And if that hurts my case, we do. It's never been, we tried to pay more than the hospital would have received if it did what Reed had expected it would do.
So you don't dispute that there is a debt?
I dispute there is a debt, probably legally. I dispute there's a debt. Morally, we think Reed should pay what Medicaid would have paid, Medican would have paid. I've struggled with how to describe that, but the truth of the matter is I'm not here to avoid paying a reasonable amount of money for what Mr. Reed received. That's not the purpose of this lawsuit. It's not something that he would consider to be a just result. But this is the only, I started talking about why this case is different. There is no other case where the hospital executives have been deposed and faced with these exact charges. They have described in their own words these charges as fraudulent, excessive. I think one of the auditors, we said, why would this be this expensive? It was their expert. And he said, I don't know, maybe it's made of gold. I mean, they're joking about it. It's like they describe some of the charges in Reed's bill as it being a $2,000 hammer in a government contract. Mr. Reed is not the United States government. The man is an indigent, broken man. And this hospital, And frankly, I was looking at it, if they accidentally charged him for things he didn't get, that might be a mistake. But continuing to seek to enforce those charges against him once it's been made apparent that he did not receive the goods, that's something that has to be protected by the Kansas Consumer Protection Act, and he is definitely aggrieved. His money has been tied up for more than a decade. The rule that the Court of Appeals created is an unprecedented, unworkable rule. Basically what it says is no matter how outrageous or how egregious the charges in a hospital lien are, as long as the hospital uses that method of enforcement, no harm, no foul. And so in that case, hospitals could be free to add, and we're seeing it. We're seeing charges for things like trauma charge, $20,000, and there's no description, it just gets added. What happens then is the patient's money gets encumbered, and it's incumbent upon the patient to come fight that. And frankly, what we're seeing is the patient doesn't get a lot of due process in that regard anyway.
But I understood you to answer Justice Byers' question on whether you're claiming consumer protection violation for enforcement that you weren't, and now you're complaining that they are continuing to try to enforce a lien for charges they admit were improper, but you're not making that as a consumer protection claim, as unconscionable?
No, I'm saying that they are using the lien system. They are seeking a judgment. And you'll hear that they're only seeking an amount that's fair or something like that. But the judgment requested is requested in dollars and cents based on a lien that's stated in dollars and cents in specific itemized charges. That's what they want to collect from Reed. That attempt to collect that, whether you do it through a lien, whether you do it through a contract action, whether you do it through a third-party debt collector, aggrieves Reed, and if those charges are deceptive or unconscionable, the Kansas Consumer Protection Act should protect him if he can establish that it is in fact deceptive or unconscionable.
So you're saying that, I'm trying to square what you're saying right now with what you said earlier.
Maybe
so you're saying that it's an unconscionable or deceptive practice to try to continue to enforce a lien on charges for items that weren't delivered, either product or services. And when you answered earlier that your consumer protection only applied to charges, you meant the enforcement of those charges? Or,
yes, I think maybe we weren't communicating.
Counsel,
I'm sorry.
I think it'd be helpful if you'd let the justice finish his question and then answer. Thank you.
The specific question to you is, are you making a consumer protection claim based on manner of enforcement? Or on the fact that enforcement of these charges, so I guess I need to know
attempting to collect these charges through the prosecution of a hospital lien, I am making that claim. I don't think that there's anything inherently wrong with leaning against a patient's or the recovery. So it's the combination of the charges.
You're just not getting it here. We're trying to square what you're saying today with what the Court of Appeals opinion stated, and whether the Court of Appeals missed part of your argument or whether you didn't make it correctly. And so what you need to tell us today is why we should consider a claim for the manner in which the hospital's trying to enforce these charges that you say are bogus.
Okay. The question as framed by the Court of Appeals is whether Reed is aggrieved by the lien and the attempted enforcement of the lien. The lien encumbered Ivan Reed's money. It has tied up his money for more than a decade. Via Christi, through this process, has become aware of charges for things it did not deliver and other complaints that we've got. It has continued to prosecute this lien and seek a judgment against Mr. Reed. That activity is the attempt to enforce a consumer transaction, which is what brings it within the scope of the Kansas Consumer Protection Act.
Is there a pretrial order in this case?
No.
Okay.
Let me go back to my why this
So
case.
if I understand it, if a hospital enforces a lien where there are appropriate charges, you're saying that's not a violation of the Consumer Protection Act.
That's right.
That where it crosses the line is because they have attempted to enforce a lien that encompasses inflated or inappropriate charges.
That's right, and I should be held to the burden of proving that. I should have to go prove that. It's not just that I say, hey, the charges are too high, look, these are crazy. If the hospital has a justification, look, our overhead is such, or we spend all this money helping people that don't pay their bills, they can come with that evidence. All I'm saying is I should be able to present my evidence, and I've met my burden of production to show in a number of ways why these charges are deceptive and inflated. And if I can show that, and they've tied up Mr. Reed's money and continue to prosecute this lien against him, it's no different than prosecuting a collection action or anything else. If I tie up somebody's property, I have aggrieved them. I have invaded their legal rights and affected their monetary interests.
How does that square with the number of counts that you've alleged?
We alleged counts in the beginning because we hadn't done any discovery, so these are compulsory counterclaims, essentially. I'm not claiming this is a $30 million case. I saw that in the brief. There's a case called Morrison versus Oshman's where this court made very clear that if you get a large number of violations and the court awards anywhere near the maximum, that's probably going to be considered a abuse of discretion. I don't think this is a $30 million case. I don't think this is a $1 million case, although counsel for both sides have probably put about that much work into it. But that's not what we were seeking. That's a misstatement of our intention. I do say that when you allege charges on an a la carte basis, the patient, is entitled to have those charges considered. You say I got 5 IV start kits. They cost you 60 cents a piece. You're selling them to me for $70. Your people admit that that's excessive. I think a jury can say that's 5 counts. It might just be 1 count. That's kind of an issue of first impression. Do I expect that the court's going to award me $20,000 for each of those 5 counts if it's 5? Heck no. So that's not the intention.
I'd like to go back to what 2 of my colleagues have been talking about to see if I can understand what you're saying. The content of the bills you regard as a violation of the KCPA. Is that right?
The charges, yes.
The charges. And you also are claiming that their enforcement efforts through the lien is itself, i.e. the manner of enforcing their charges, that by itself is a violation of the KCPA? Or do you have to have the cook that they're tying up his money for 10 years to make that a separate violation?
I think the tying up the money makes him agree. The charges are a consumer transaction using the lien or a third-party debt collector or a lawsuit. Any of those would be an attempt to enforce a consumer transaction. I think you need the combination of them to get there. I don't think any one of them standing on their own is enough. If the charges were never delivered to Mr. Reed and only internally accounted, I wouldn't have what could I say about that? I would have a Finstad problem there.
All right, thank you.
Thank you. And my time's up, so I'll yield the floor.
Before you sit down, do we have any further questions of counsel? Thank you.
May it please the court, Jay Fowler on behalf of Via Christi. Justice Nuss, let me address the point you just raised about whether or not there was a contention that it was a violation of the Consumer Protection Act to simply print off and submit a bill with the itemized charges. That question was asked by Judge Lien in the Court of Appeals. And Mr. Grable, arguing on behalf of Mr. Reed, admitted that simply presenting his client with a bill of itemized charges was not a violation of the Kansas Consumer Protection Act. There's a lot to this case, but we think that
was not alleged
was not a violation.
He admitted the legal standard, or he admitted he wasn't seeking that?
He was asked a specific question. Are you claiming that it is a violation?
It was about his claim. not
Yeah.
about the legal standard. Okay,
The
that's what I was getting.
KCPA, if you simply present the bill to the patient, and the answer was no, we are not making that claim.
Okay, thank you.
There's a lot of background to that. I mean, that bill was used in negotiations of the personal injury claim. There was an element of damages in that case. There's a lot going on here. That bill was an evidentiary item in another case advanced by Mr. Reed. There's a lot in this case, but we want and believe that the Court of Appeals did a very good job with this case. We embraced Judge Lieben's decision. It was well done. He addressed the lien issues, the public policy issues, reconciled competing considerations, and reached a result that affirmed the district court on both the KCPA claims and the lien claims. We urge this court to consider that as a guide to this court's resolution. That was good judging in our view.
I think that's inevitable on a petition for review. That's going to be a starting place for us. But I want to ask you about a few of his points.
All right.
First of all, one of his primary legal holdings was that you don't need a debt to have a lien. Are you agreeing with that point?
I agree with that point, but I also agree or believe there was a debt. I think Judge Lieben's opinion is fairly read to say, we don't need to address this issue you've raised, because under the lien statute, the lien arises by virtue of the provision of services. And it's created by virtue of that, and so we're not going to get into a debt analysis. Now, I will tell you that we believe that Mr. Reed's reading of this contract issue is a dramatic over-reading of the document. Justice Breyer, you acknowledged and read paragraph 4 of that document, but if you go down to the bottom of it, you will see that Mr. Reed's sister did not sign the document as a responsible party. She signed it in an other capacity. And bear in mind that Ivan Reed hadn't talked to her about signing the document. He was in surgery or unconscious at the time. So she simply signs off as an other person, and there's a lot in this document that they're asking about authorizations for treatment and things like that. So we do not think that this is a contractual document for provision of free services, which is the position they've taken below. There's also an implied debt created by virtue of the provision of medical services. There's case law on that. There's a quantum merit basis for compensation. There's an unjust enrichment theory. So there's a lot of reasons why that debt element.
So you happen to agree that you don't need a debt, but you think there was a debt here, and
Exactly.
we can therefore avoid tangling with Judge Lieben on the debt question.
I think you can. I mean, there's multiple reasons to get to the same way, and Judge Lieben reached a very appropriate decision.
Okay. Even though it's esoteric, help me understand. I understand that the statute is written as the provision of service is what initially triggers it. But do you think you could have a lien if the patient had paid you on the spot for that service?
Well, no.
So there has to be a debt before you could claim a lien.
Well,
It has to be, the service has to have been rendered and it has to have been unpaid.
Well, there has to be an obligation of some sort. I mean, they could, whether it be based on equitable principles or whatever, you can't lien something that didn't occur.
So there does have to be a debt of some sort.
There has to be an obligation. The question is the debt based on contract? No, we don't think there has to be. But the hospital has to perform a service and have a charge, and that's very true. That's very true.
It seems like it makes a lot more common sense too, doesn't it? A lien is a security interest. It's not the debt in and of itself. But we don't need to debate that. We've already established we may have a workaround on that question. What about Judge Lieben's holding, or the Court of Appeals holding through Judge Lieben, that the lien process itself, the hospital lien process itself, means that as a matter of law you can't have an unconscionable act or practice?
Well, we agree with it, and here's why. Let's understand the background of how this came about. There was a settlement of a lawsuit. In the settlement documents itself, there is an acknowledgement that the lien of via Christi, and that it will be protected or satisfied in some fashion. And that's the UP and the plaintiff agreeing that occurs. That money is then put into a trust account by agreement with Via Christi. And there's a negotiation over whether or not the amount could be compromised. They cannot compromise. Under the lien statute, the way to resolve that question is to go to the district court, and that's what Via Christi did.
Make an equitable distribution above the $5,000 mark.
And if you go look at our petition, we asked for distribution. And the court has to determine what's reasonable and necessary. And that's the frustration the hospital has, because we did what the statute envisions us doing. If there's going to be a dispute about what the appropriate charge is, the district court gets to resolve it. We invoke the procedure as provided in the lien statute. We didn't separately sue Mr. Reed. We exercised our rights under the statute for distribution of the proceeds and a finding of what was reasonable.
So that was your petition only prayed for that, not for the $84,000.
We did not sue on contract. We did not sue on any separate theory. We simply asked for the court to determine the proceeds that should be distributed. Very simple pleading. And that gets around this whole notion of Consumer Protection Act. We are acting in a protected manner in this fashion. How else do we resolve?
Excuse me for interrupting. So it isn't really a situation where, I guess what was troubling me about the Court of Appeals opinion is that it seemed to me overbroad, that the holding was overbroad. You're suggesting that in this case, there can't be a Consumer Protection Act violation because you're not actually engaging in conduct to enforce a debt certain for X amount of dollars. You're just saying, hey, we just want to go to court and have the court decide like we always do.
Yeah, we're saying we have a dispute.
But would you agree with me that there are circumstances where a hospital could be engaging in an unconscionable act or practice under the Act if, for example, it just didn't provide services, but for whatever reason it's pursuing someone? Or, I mean, there are circumstances where it could arise. The fact that it has a lien statute or a set of statutes assisting it with collection of its debts through a lien doesn't make it immune somehow from the Kansas Consumer Protection Act, does it?
Well, I agree, and we're only asking the court to judge this case on this set of facts, not some other set of facts.
That's what I was getting at. You started by saying we agree with Judge Levin. We think you wrote a terrific opinion, and I think you said you also agreed with that holding. But that holding is really far more broad than it needs to be to cover your case.
No, I don't think so, because the holding is shaped by the facts that he reports in the opinion of the case.
Okay.
I mean, you have the case before you and that's the rule, and he's saying in this instance, going to the court and asking for a distribution under the lien statute is your right.
So if we're reading it as a bit more muscular than that, you think we're misreading it?
I think so. If you think it's the Immunity Act for hospitals, no, we're not claiming that at all. But I want to also make it clear that there's a very different approach by the parties as to this pricing issue. The plaintiff, Mr. Reed, wants to segregate each charge and point out that you charge one thing for this and one thing for that, and oh my God, that's too much. We've had evidence in this case, evidence by both sides that this issue was presented on a summary judgment by both sides, and the evidence was that Via Christi's pricing for the DRG 486 was actually lower than all of its competitive hospitals in the state of Kansas. The average charge for the charge per day was around $6,000. And if you look at the KU Med Center, you look at Wesley, you look at the other competitive institutions, Via Christi charges were low. This gentleman was in the hospital for 14 days, 6 days in intensive care, and his total charge was a little over $80,000. The charge to cost ratio of Via Christi was like 273%, which was lower than many hospitals in the state of Kansas. In other words, we think we provided a good value for him. We saved his life and his limbs. They had multiple surgeries. He got full benefit of all of that for a cost on a comparative basis that is cheaper than many other hospitals in the state. And that goes to the heart of the Consumer Protection Act claim, because unconscionability is based on what other suppliers would do.
So it's your contention, and I'll just use a hypothetical, if all the other hospitals would charge $10 million for this and Via Christi charged only $8 million, then it is by definition not unconscionable?
What I'm saying is the KCPA defines unconscionability vis-a-vis what's going on in the community, and we have measured the standard. I don't necessarily like hypotheticals because that's a different set of facts. We're stuck with the facts we have, and the facts we have demonstrate that Via Christi's charges are lower than the prevailing charges for the same kind of treatment in this community, in this state. And in fact, Mr. Reed had an expert witness, an economist, a healthcare economist, who acknowledged that Via Christi's practices were very similar to the practice of his own hospital. And so that's really why this isn't a Consumer Protection Act case. And there are a whole series of things in this pricing deal and discounts. Via Christi does negotiate charges. They try to negotiate the charges here. They have an indigence policy if you can't afford it. If you would file an application for charity care, they will give you a reduction in your bill. Mr. Reed did not do that. And that all goes to the heart of Via Christi's conduct in this case. Via Christi performed life-saving services. They rendered a bill that was consistent with or lower than other bills in the state of Kansas for the same kind of services. They offer the plaintiff an opportunity to seek a reduction if he's got financial necessity. He doesn't complete the procedure, and then he sues us for millions of dollars of damages on a KCPA claim. And all we ever ask, the predicate act, all we ever asked was for the court to make an equitable distribution of the lien. We didn't sue him, didn't send him to collection. All we ask is do what's fair. That's a pretty tough case to make in our view for a KCPA violation.
Can we move on to another subject?
Absolutely.
Before your time runs out? I want to talk about compliance with the lien statute,
all right,
and notice provisions. It looked to me that you might be arguing that there was strict compliance in addition to substantial compliance. Is that right or not?
It's sort of right.
Okay.
There was strict compliance with the lien statute vis-a-vis Mr. Reed. He got the notice. His lawyers got the notice.
Right.
What did not happen is Via Christi did not send a certified or registered letter to the Union Pacific.
Right.
That's what didn't happen.
Right. And
UP
you're
knew about
suggesting, so obviously that's zero compliance with the UP part.
It is zero compliance, but there's some factors that go into that Judge Lien noted. Number one, the UP knew about it. In fact, they entered into a settlement agreement between Reed and the UP that specifically recognized and embraced the notion that lien was existed and needed to be protected. And there was a whole series of negotiations and then the transfer to the trust account of Reed's counsel for the purposes of protecting that issue. So there is, in our view, more than substantial compliance. But if we are required to send a registered or certified letter to a third party who's not here, by the way, involved in the dispute because the claim was not brought against them, if we're required to do that, then we lose the case.
So your substantial compliance argument is they had actual notice.
They had actual notice, and they not only had actual notice, but they proactively engaged in a contract.
And that's not disputed by the parties. Okay,
And,
so they had actual notice. But how does that reading of the statute square with what we've been doing with statutory interpretation, as opposed to what Judge Lien advocates we do with statutory interpretation?
You have to go to the public policy and the practical applications.
Not always.
Well,
if the language is clear, we generally say we don't. And that seems like your problem to me.
I think you'd be going against the weight of authority in this particular situation. I mean, there is authority under Kansas law that once the lien is created, then you have more liberal interpretations toward the subsequent procedures. Mm-hmm. Here, the lien is created not by virtue of sending the notice,
but by providing the services.
And I think that is a key point.
Difference between attachment and perfection.
Right, and so our enforcement, and so what we have here is we have a lien created under the statute, which I think everybody ought to agree happened. It's a statutory right created by the provision of the services. And now we have an enforcement issue, which the court, I think, has the ability to articulate the public policy rationale that Judge Lien recognized. And let's sit back and just think about the practical implications of a totally strict compliance rule. These folks come into the hospital. A lot of times they're unconscious. They may ultimately die. Certainly they don't have necessarily themselves full information about who was a potential tortfeasor and who may have an obligation. The hospital is not an agent to investigate that. They don't have the information a lot of times as to who that third party is that may ultimately be liable. And so the hospitals do the best they can.
That sounds like something to go talk to the legislature about.
Well,
because the statute does say, it doesn't equivocate. If you know, it says you must give the notice, doesn't it?
It does say that, but then I go back to the notion that that's not a lien creation portion of the statute, and that in this instance where we have substantial compliance, we have satisfied the obligation.
So are you suggesting that it's ambiguous?
What?
Are you suggesting that that provision of the statute is ambiguous, at least when read with the previous provision on attachment?
I would think it might be, I suppose.
I think you almost have to argue that in order to get to policy and practicality.
What the argument is that you have to provide written notice to a third party who no longer has an interest in this thing.
We appreciate that.
Yeah,
about this particular situation.
and to make that lien effective. And what we're saying is strict compliance is okay against everybody you're trying to enforce the lien against. That's what we're saying. And this money is not in the UP's hands. This money is in the plaintiff's counsel's trust account. And so it's not a matter of enforcing against the UP. The UP recognizes the lien.
Help me with the statutory language. It starts by saying no such lien shall be effective unless, then it talks about a first notice that must be sent, which I think is to the clerk of the court, and then it says nor unless the hospital shall also send. So why is that not also saying the lien is not effective unless the second notice is sent? Am I misreading the language?
Well, I mean,
am I not understanding your argument?
No, I mean that is a literal reading of the language. I mean, the words do say what they say, but the question then goes to how that language should be interpreted. And we believe it's consistent with the public policy rationale that Judge Lien recognized, and the fact that there's another statute that creates the lien, that substantial compliance, if there's actual notice, is sufficient. That's what we believe.
So we're getting outside the plain language of the statute. It sounds like you're conceding, and now you're asking us to get into public policy, which I think ties in with the comment perhaps Justice Johnson made about, isn't that an argument you should make to the legislature?
Well, no, I don't think so, because I think this court has already recognized the substantial compliance doctrine in connection with liens, particularly in context where you're talking about the enforcement of the lien. I think this court has recognized that. If this court believes as a matter of law we were required to send a registered letter to the Union Pacific in order, then we lose. If that's the requirement, we didn't do that. Everything else was done. The notice was had. They agreed to protect it. So there's no unfairness here. And so we think substantial compliance works. If strict compliance, including the requirement of that certified letter, is required, then we did not do it. But we don't think
perhaps your better argument is that Reed didn't have standing to complain about the lack of notice to Union Pacific, that it was designed, the notice to Union Pacific was designed to protect that entity.
I agree. That's inherently part of it. You notice the Union Pacific is not.
But we would have to read that into the statute also, wouldn't we?
Well, I mean, it goes back to the notion of what the purpose of that statute is. The purpose is to avoid someone getting stuck with a lien when they didn't know about it. That's the purpose.
It's protect Union Pacific. Is that your point?
Protect the Union Pacific, yes.
And the functional equivalent has already been established because of the plaintiff's participation in the settlement agreement and preserving or protecting or at least acknowledging their claim.
Right. At this point, all the parties necessary to the adjudication of the lien have had actual notice of the lien, have had statutory compliance. I mean, it's the lawyer who's holding the trust fund now. It is Mr. Reed. And that's where this lien is. This lien has moved over here. It's not over there with the Union Pacific anymore. It has now moved over here by the voluntary act of all concerned placing this fund with the lawyers. That changes the character of this situation, we believe.
Mr. Fowler, the thing I've struggled with in reading this are the ramifications of what you're asking for with the hospital lien with the mechanics lien statute. So I guess my question to you is, do you think that the mechanics lien statute and the hospital lien statute are similar enough that I should have that concern?
I think there's a difference.
Or does it matter?
No, I think there's a difference. I think that the mechanics liens arise out of a different context. They are intended to affect title to property. They have a potentially broader reach than a hospital lien. Hospital liens are very focused. And so,
but is the language of the statutes different enough that if we interpret the hospital lien statute a particular way, we're going to be stuck with the same statutory interpretation principles applying in this other context?
No, I don't think so. I think Judge Lien addressed that in his opinion. This is a different critter, and it's a unique circumstance, and it makes, in our view, good public policy sense to follow the rationale we're suggesting.
Counsel, I see you. Go ahead. I was going to ask if we had any further questions.
Oh, okay, I do. I want to circle back to the KCPA claim. And I understand your argument to be that seeking the enforcement of the lien itself could not be a KCPA violation. But what about the step of filing the notice of the lien and the amount of the $84,000 and whatever odd dollars? If that was an amount that was above, just assuming that there would ultimately be a finding that that was an amount that was unjustified.
Well, I know that going back to Mr. Grable's comment at the Court of Appeals, he said certainly printing off the bill and providing the bill to the patient was not a violation. So you almost have to, it necessarily follows that filing the lien right wouldn't be a violation either, because all the lien does is give you the right to ask the court for a distribution for more than $5,000.
Well, it does more than that, though, doesn't it? Isn't that then what ties up the money? I mean, UP then says, okay, the potential lien is $84,000, so I'm not going to let you have $84,000.
But the method for resolution of that is very prompt. You have a short little hearing with the district court, and everybody's rights are adjudicated, and a fairness decision is made. I mean, that's the point, that there is a process in place that allows that dispute to be handled very expeditiously. This case has been pending for however many years, not because of Via Christi's request to Judge Chambers to decide what's fair. It's been pending for a lot of other reasons and a lot of other claims. So that's basically it.
Any further questions of counsel?
Just on that hearing subject, even in the Court of Appeals, you're getting sent back to have that hearing. You're not arguing that that's appropriate at this stage of the game.
Well, we thought that the record was sufficient. Judge Lieben thought it not. It's a matter of fair dispute. He ruled against us. We're okay with that. And Justice Barr, you also asked whether a pretrial order had been entered.
Yes.
I don't think a formal pretrial order had been entered, but the parties had submitted pretrial questionnaires with all their contentions and claims.
And those are in the record.
And that's in the record. Yes.
Okay, good. Helpful to know what the contentions are at the end of the case, not just the beginning.
No. The case had been pending. It has been many years, and the case was pending in the district court for several years before decision. So.
It's always good to have one if you're going to file a motion for summary judgment. Somebody taught me once. Okay.
Any further questions of counsel? Thank you, counsel. You reserve 5 minutes for rebuttal.
Thank you, Your Honor. Quickly, I want to point out the bill that was delivered to Mr. Reed, the record reflects, said $0 patient responsibility and indicated that Medicaid was pending. So when it was used, it looked like they weren't claiming any money against Ivan Reed personally, and everybody involved believed that Bates versus Hogg and would apply, and that Medicaid would limit the amount of that bill. There's nothing nefarious about the way it was used. Reed is not asking for new rules of law. You've discussed some others. I'd like to tell you what I think the ramifications are. If there's no antecedent debt required for a lien, then Kansas hospitals would be allowed to balance bill the patients. Almost all the cases that we've cited where courts have struggled with that issue, it's been to stop hospitals from taking the insurance, and they're supposed to write off the bill under the contract with insurance, and then they lien for the balance against the patients. And courts have almost universally found that to be a bad thing to do, and that's at the heart of all those cases. If Judge Lieben's rule is allowed to stand, I believe Kansas hospitals could do that. Two, just so I'm clear, I'm not sure I get the question, but we're saying that it's unconscionable to file a lien that ties up money, and it's unconscionable or illegal to use the courts to enforce a claim that the hospital knows is unjustified, to continue to do that. The journal entry that was submitted by Via Christi was for a sum certain, based on a lien that had itemized charges in a sum certain. At the end of the summary judgment process, Via Christi submitted a journal entry for a sum certain that included amounts that they admitted in the summary judgment argument were overcharges, over our objection after we pointed it out. The judgment that was entered, that's been overturned by the Court of Appeals, includes charges that everybody admits were for goods that Reed did not get. We are not saying, I heard a bunch of argument about how fair their charges are. I'm not saying that I've overcome that. All I'm saying is we've met our burden of production on summary judgment. Those are arguments that should be given to and weighed by a fact finder. I'm saying that a hospital's charges are not beyond scrutiny merely because they're attached to a hospital lien statute.
What about beyond scrutiny because they comport with other level 1 trauma hospitals?
There's a case called Colomar that we cited where the court basically said it is not probative that something is conscionable merely because it's not unconscionable merely because it's similar to unconscionable activities taken by others. I'm saying you have to weigh more evidence, and I took the time to go out and develop that evidence. And I have not been able to present that evidence yet to show what the value is vis-a-vis, is a markup of, for example, $10,000 on one good unconscionable? Is a markup of 30,000% unconscionable? Or can you justify that somehow by showing me why? Can you charge a several $100 handling fee for the cost of a nurse to deliver some medicine when you're already charging for the nurse in the room charge for the ICU? In some of these instances, the hospital internally admitted in their own meetings that they were engaging in double billing, and they decided, well, we ought to get rid of that charge, but if we lower that charge, we'll lose $4.8 million in revenue, so let's keep charging for it until 2 years from now, and then we'll get rid of it.
I'm sorry, go ahead.
These are all arguments that should be made to a fact finder. I'm not asking you to accept them. I'm asking you to acknowledge that I've met my burden of production.
I was going to ask, and you may have just answered it, the determination of whether something is unconscionable is a question of fact?
Yeah, it is a mixed question of fact and law for the court, I believe. And it is broader than has been represented. I think every time the court's looked at it, like in the Willie case, you say it can't be limited, or if its application is limited, then it doesn't work, or something like that. And you have factors. The KCPA specifically says they're not exclusive. In Willie, it says they're not exclusive, but cost-price disparity, for example, is one of them. And you will never see a case come before this court where the cost-price disparity that can be proven by uncontroverted facts is greater than it is here. So that factor is in play. It may not carry the day for me, but it meets my burden of production.
Counsel,
Yes.
I just want to make sure what you were getting at a few minutes ago when you talked about what the claim was as the case went up to the Court of Appeals. So your answer to your opposing counsel's argument is, hey, we never asked for the money. We asked for an equitable distribution. Your response is, no, they wanted the money.
They want the money.
They want all the money.
They want the money, and there's a case that I can...
That's because of what again, you said?
The money belongs to Ivan Reed.
Just a moment.
I'm sorry.
I think we're not communicating.
Okay.
What did you say that they submitted later in the case that indicated they want the full amount as opposed to an equitable distribution?
The bill said $0 owed by Ivan Reed. The lien said $84,000 and some odd dollars, and was later supposedly reduced to $83,000.
Right, but your opposing counsel's point is that when you submit a lien statement, you are just asking the court to make an equitable distribution of all the amount over $5,000.
No, when you file a lien statement, you're saying, I have an interest in your money and I intend to tie up your money.
So you disagree with his reading of what that means.
And
you're not asserting that there was a later point in the 10 years of litigation where they submitted a claim that said it has to be this amount or nothing.
They did it. Yes, they did. They all through the litigation. The court never sat down and looked at the charges. The court entered a journal entry
Well, that's
for the
what
amount
Judge
being
Lieben was sending it back for. Was
Yeah,
that
no,
equitable distribution
They got it-
of that money?
And if I could make one final point, it's
course.
a little complicated.
Okay.
I don't believe the equitable distribution section of 65406C is a private cause of action. I think when
I saw that in your
hospital
brief.
liens used to be for $5,000, the hospitals went to the legislature and they got an unlimited lien only for the reasonable amount of the charges. So let's say the hospital's charge is $100,000. They have a lien for that amount. If 65406C did not exist, they could still enforce that lien through the lien enforcement statute.
But if
the equitable
but if the
distribution
person
allows
holding the money just refuses to pay,
then they file a lien enforcement. But the 65406C talks about equity. Equity follows the law. From the hospital's perspective, the lien is to the reasonable extent of the charges. Equity's not going to move it forward. It's only going to move it down. And it doesn't affect what the patient owes. It's a security interest. It's just saying, of this money we're going to get, I need some of it to eat on or to pay my bills on or to pay these other medical providers. The hospital can still sue the patient for the full amount of their reasonable charges. The lien is a security interest, and all 65406C does is limit the scope of enforcement of the lien. And then lastly, none of the cases that you discussed, the authorities that were cited about the lien statute being strictly construed, there are cases. One of them involves via Christi and shows there's a pattern. None of those cases use the word ambiguous. The word effective is not ambiguous. The dictionary definition is actually in operation or in force. So you can look at all those cases. You won't find a single finding that statute is ambiguous. This is judicial legislation. I agree it's an argument for the legislature.
Do we have any further questions of counsel? Thank you, counsel.
Thank you for your time.
Thank you both for your arguments this morning. The court will take this matter under advisement.